For more on the verdict, let's bring in Karen McArthur. Karen is a criminal defense lawyer, and we've reached her in Toronto. Karen, thank you so much for making time for us. What is your initial reaction to this verdict?
Well, 4 of the complainants were believed, and the 5th complainant, it took a lot of courage for her to step up to the plate and tell her the story of this intimate violence against her. My reaction is he's an elderly man. I don't know what the sentence he will receive, probably something between 5 to 10 years. And he still has to face the music in Manitoba, Quebec, and a class action suit in the United States of America. This verdict brings closure, but it doesn't completely write the book on Peter Nygard.
I want to talk to you about the possible sentence and the possible appeal. But first, I want to ask you about the major challenges in this case. What were some of the major obstacles in this case?
Well, Crowns in cases like this where you have multi-complainants usually or quite frequently resort to this similar fact application. They bring it before the trial judge and say, listen, trial judge, we'd like to put in this discreditable character evidence, which is presumptively inadmissible. But please, judge, let us put it in so that the jury can consider whether or not this adds to our case of proving guilt of the accused. And in this case, Justice Goldstein was persuaded, and he did allow similar fact evidence. So he allowed, I believe, complainants that weren't actually one of the 5 complainants in this case to come and tell similar stories of activities that or actions that Peter Nygard had done with them. And additionally, because there were 5 complainants, Justice Goldstein allowed the Crown to use this evidence, this presumptively inadmissible evidence, for cross-count supporting or shoring up the evidence of one complainant with the evidence of another complainant and another complainant. That's called cross-count admissibility. It's a bit of a minefield because in a jury trial, the judge addresses the jurors on the law and the proper application of the law, and that can take a day or 2 days. And then he sends them off, he or she, in this case it was a he, Justice Goldstein, sends the 12 people off to a room where, having learned the law or being taught the law by the judge, they then have to apply the law to the facts. It's a minefield, though, to apply what Justice Goldstein told the jurors when it comes to similar fact. And I understand that Brian Greenspan, Peter Nygard's lawyer, has said they're going to sort of go away and look at some of the rulings and consider whether or not they can appeal this jury finding. Appeals, so your viewers know, are generally, they go to the next higher level court. So this will be to the Court of Appeal. And the Court of Appeal looks at whether or not errors in law were made by the trial judge. So they look at whether or not errors in law. They don't revisit everything. It sort of becomes like a law school exam. And I like to tell people that it's a bit like a funnel. And as you go up the appeal route, things get tighter and tighter. So it's not like if they do decide to appeal that it will all be open season again. They'll have to establish that errors of law were made by the judge. And it's not easy to get sexual assault convictions set aside at any Court of Appeal, let alone the Ontario Court of Appeal.
Thank you so much for outlining that for us and also for explaining that strategy of the Crown that, while perhaps risky, did pay off in this case. Tell me, how might this verdict influence future cases involving sexual assault? We've had so many high-profile cases of sexual assault in Canada, as well as cases in the U.S. that Canadians were watching with great interest. Within the Canadian legal system, what effect do you think this outcome is going to have?
So look, you had 5 complainants here that had the courage to go up against a very, very wealthy man with a lot of power, just as we saw south of the border with Epstein and Weinstein. So a verdict like this signals to persons that have, been on the receiving end of ugliness and violence that the courts will hear their stories, will treat them with dignity, and their stories may well be believed and justice may be delivered up on a platter for the person that committed violence against them. So I think this will embolden complainants and persons that have been at the receiving end of sexual violence.
Thank you so much, Karen. Criminal defense lawyer Karen McArthur.